Swayam Prabha. Digital India. Educated India.
Good afternoon. This is lecture number 13, and in this lecture we will be trying to understand about our own legal system, which is Indian legal system. What are the features of our legal system? How is this different from the other legal systems of the whole world? And what are some of the examples by which we can say that yes, this is a most important thing about our legal system. These are the things that we will try to understand in this lecture today. So, welcome all of you to this lecture on the Indian legal system. As we all know that the legal system means a system. So, it is based upon some mechanism which has been already laid down, on the basis of which the system works. But if the system is only having just a kind of mechanism, then it will not be considered a good legal system. So, what are the principles, what are the values of our legal system? That also we will try to understand in a different lecture. But in this lecture, what we will try to understand is that what is this system all about? Are we influenced by the major legal systems of the world or not? Or we are our own unique legal system, which may be sui generis or not. So, these are the things that we will try to understand in this legal system. What are the elements of our legal system? Then we will say that is our legal system having the feature of the major legal systems of the whole world. In the last lecture, we have tried to understand that the major legal systems of the whole world are 2 in number, or maybe 3. So, major are 3 in number. What are those 3? First was the common law family of legal systems, the second was the civil law family of legal systems, and the third was socialist family of legal systems. Now, what we will try to know that whether our own legal system is influenced by these legal systems. The answer is that our legal system is mostly based upon the common law family of legal systems. Why I am saying so? Because if you remember that what were the features of the common law family of legal systems, I had told you that the first feature of common law family of legal system is that the importance of the courts and the importance of the judgments of the courts and the quality of the judgments of the courts of the common law family. So, these are the things that are also present in our legal system, and therefore, we will try to see that how this system, which was called as the common law. And what was the second thing that I told you? The second thing I told you about the common law family was that it was based upon adversarial system. The parties are considered adversaries to each other. They are considered enemies in the courtroom, and then the judge plays a neutral role in the whole process, and finally, the judge gives the judgment. So, the common law family of legal system, if a country becomes the member or is a member of the common law family of legal systems, it means that the judgment will be given priority and the judgment will be having weightage, the judgment would be binding upon the parties, and it will be considered judicial precedent if it is given by the higher courts, and also that it will follow adversarial proceedings. Now, we will see that whether these things are present in our own legal system or not. So, in our legal system you will find that in substance these features are there. The feature of adversarial system, the feature of judges playing neutral part in the whole procedure, that is there, and therefore, substantially we are following the common law family of legal system. But whether there is any influence of the civil law family of legal system, the answer is to a small extent this is also relevant. We are influenced by the civil law family of legal systems. How? The answer is, what were the traits of the civil law family of legal systems? The first trait was that importance was laid not on judicial precedents, but on the legislation. In our legal system, what is the fact? The fact is, in our legal system, the judgments are also given importance and legislation is also given importance. So, our legal system is a mixture of the civil law as well as the common law family of legal systems, because we give equal weightage to the legislation as well as the judicial precedent which is followed in the common law family of legal systems. So, the civil law family of legal system is also in this way having influence. What is the second thing that we discussed in the last lecture about the civil law family? We discussed about inquisitorial system. Whether inquisitorial system is also found in our legal system. In the Indian legal system, can we find inquisitorial approach? The answer is, to a small extent, yes. Why I am saying so? Because of the fact that in the inquisitorial system, I told you, judge plays an active role in the whole process of dispute settlement. And if you look at the codified laws, then you will find that there is a provision in our law by which the judge plays an active role in the settlement of disputes, and that I will tell you later on. But what I was just saying, because this is going to be an introduction to our own legal system. So, what I was saying, that the second thing which was important, that inquisitorial system has also influence over our own legal system. Then we are influenced by the practices, religious practices of different peoples. In our country, there are different sects, different religions, and therefore, the Hindu laws and the Islamic laws, they also apply to the communities which are there. And therefore, our legal system is a combination of the different streams coming together, and then the great stream of Indian legal system is formed. When it comes to the common law family of legal systems, I had told you that common law family relies upon judicial precedents. So, how this system of judicial precedents work, that one of the important features of our legal system is that the judges who are there, they are retiring at the age of 65 years. So, not all the judges of the Supreme Court, they retire at the age of 65 years, and the retirement age of High Court judges is 62 years, and the rest of the judges is 60 years. So, you see that when they are retiring, then what they do, that they have a base in the common law, they have all the skills of the common law, and then they are being transferred, or sometimes after retirement they are given a job in the tribunals or the commissions. So, this practice, and when they are appointed in the tribunals or commissions, they are the chairpersons of the tribunals and commissions. Now, this practice has given rise to the system where the common law has a lot of influence over the tribunals. If this would not have been the practice, then maybe that tribunals would retain its original character, but the tribunals are not having the character of the civil law family of legal systems. Rather, the tribunals or the commissions, they are still having the common law tradition, because you see that common law mainly have those judges who have such kind of skills in writing the judgments. And the presence of advocates in our legal system, although we will have a different lecture on the advocates and how the people who are practicing in the courts, how they have been organized. But as far as the advocates are concerned, in our legal system, the advocates are also organized into a body of people, and there is a separate law by which they are governed. There is a Advocates Act for them. So the advocates who are there, they are also trained in the common law tradition. When you go to the High Court and the Supreme Court, you will find that they have to address the judges as my lord or your lordship. So this is the whole feudal or monarchical kind of system of common law. But this practice should not be there in the civil law family, or the examples or the application is the tribunal system or the commission system. At least in the commission and the tribunals, there should not have been the address of judges as your lordship or my lord. So you see that the main what we say, the main basis of our legal system, which still has the color of the common law family, now that sometimes has to be rethought, and maybe that the government will be doing something by which we can try to make a change in this way, that how our legal system, because the main difficulty is pendency of the matters in the court. Crores of litigations are still there, 5 crore, almost 5 crore problems are there which are lying in the court, pendency is there. How to remove that pendency? Whether the common law family's influence has to be maintained, or we should try to think in different directions which system we have to follow. And this is what you should also develop, this ability of thinking, that which legal system may be helping our legal system, so that there will be no pendency of cases in our country. But in this lecture, what I will tell you next is that the legislation is also very important. In our legal system, I told you legislation is also very important for a judge. So how is this legislation or codification that is there in our legal system? You will find that our legal system is one of the oldest legal systems of the world, which started with the codification of law in the modern times. In the olden times also we had codified laws, but in the modern times, when it comes to the modern time also, we will say that we are one of the first countries in the whole world to have codified laws in our country, and which is a trend of the civil law family of legal system, which is not a trend of the common law family of legal system, because common law, I told you in the last lecture, common law does not give lot of importance to the codified laws, rather it gives importance to the judicial precedents. So in the Indian legal system, what we find that the earliest start of codified laws, you remember that the first law commission of India, which was established during the British time, that had started the codification of the basic laws, because the Britishers were first of all inclined to rule peacefully in this country, and what they did, that they started with the accumulation or the codification of the penal laws and the procedural laws, and also the laws relating to evidence. So first of all they tried to assimilate, codify these laws. So the first codification was successful, and first, second, third, all these were successful, and you will find that in the 1859, 1860, you will find that Indian Penal Code and in Criminal Procedure Code and Indian Evidence Act, all these three basic laws were codified by the first Law Commission of India. So, you see that this was successful, and the codification, which was a trend in the civil law family of legal system, that also started in our country. And you see, we were even before the Britishers later on. I told you that this was a place of experimentation. They experimented first of all in the colonies. They tried to test upon the people like us, black people, or people who were not fair, who were not white. So, first of all they tested on them, and then later on they, when it was successful, they considered that okay, this is successful, then they will emulate it in their own country. So, that is how our legal system that started, but you will wonder that whether the codification was influenced by the civil law family of legal system also in another way. One was that the overall trend of what we say that the codification itself is a first of all first indication of the civil law family of legal system. But the second thing is that what are the other things which are influenced by the civil law family of legal system. The other thing was that if you look at the Indian Penal Code also, you will find that it was influenced by other legal systems, other codified laws on this area. For example, what we find that Louisiana Penal Code, and you know Louisiana Penal Code, where is Louisiana? Louisiana is in the US, and there was a penal code which had been drafted by the French people. So, France ruled over that part of US, now it is in US, but earlier when even America became independent, at that time it was a French colony. So, Louisiana had a penal law which was codified. So, when our law of, on the crimes and punishment, those were codified, at that moment of time Louisiana Penal Code was also studied by the drafters. And who were the drafters? You might have heard about Lord Macaulay. Macaulay was the what we say chairperson of the first Law Commission. So, Macaulay tried to examine, understand the other legal systems, other codes, examples of codes, and he was himself a Scot. Macaulay, you will be also surprised to know that he was not of a pure British region. He was from Scotland, and you see what that Macaulay had a kind of influence of the continental system, which is the civil law family of legal system, because Macaulay was trained in the Scotland, and Scotland also had influence of the civil law family of legal system. So, he knew the importance of codification, and the moment Britishers started saying that we need to codify for the natives, then Macaulay was brought in, and Macaulay was given this task to codify the laws. In our legal system, we find that there is a kind of mixture of civil law family of legal system and the common law family, because common law is the base. You all know that common law is the base of our legal system. So, what I tell you that in our legal system, Indian Penal Code can be one example where we find the influence of the civil law family also. Although it is a purely, it was all the people who were involved in codification of Indian Penal Code and Indian Evidence Act, they were all from the UK and they were all colonizers, but still they had also tried to understand other legal system. When I tell you about the Indian Contract Act, you will again be surprised to know that in the Indian Contract Act, normally we understand that all the laws, all the sections are imported from Britain, and the whole concept of English contract, English type of contract, that has been accepted in the Indian Contract Act. But if you go further and examine some portions of the Indian Contract Act. For example, section 25 of the Indian Contract Act. Section 25 states that if there is no consideration in particular given cases, then also there can be a possibility of contract, which was not there in Britain. So, the law on contract in our country to some extent is different from the common law origin. In the English legal system, there cannot be any possibility of a contract without consideration. And therefore, when I ask my students that, do you know that the law on consideration in our country is different? They all say, how is it different? It is not, is it not based upon the Britishers? Then I say that no, you look that the law is that without consideration, if there is a promise and there is a acceptance, then maybe that if it is an agreement which is coming out of love and affection, and if it is registered, then there is no need of consideration in all such cases. So, you see that this is a departure. I am not saying that this is a feature of the civil law family of legal system, but this is a departure from the British legal system, which was a common law family, but still there was a kind of departure on the basis of what was the practice on contract there in our also in our own country. So, sometimes you see that the common law family, although our legal system is based upon the common law family, but still the drafters of the different laws, they also wanted to study and incorporated little bit of the domestic practices into the legal system, into the laws which were framed at that time. So, Indian Contract Act is also one of the things, and you know what, there was at that moment of time in New York a civil code had been framed. So, when the Indian Contract Act was also going to be drafted, at that time the drafters of our Contract Act, they also studied the New York Civil Code. So, you see that New York Civil Code, New York was kind of common law family, but then studying of a codified work, that was also important. So, you see that our legal system, the early development in our legal system was a kind of also mixture of the common law family mainly, but then again to the civil law family of legal system. Then we can also try to understand that when it comes to inquisitorial system, because I told you that inquisitorial system is also one of the features of the civil law family of legal system. Whether the inquisitorial system is followed in our legal procedure or the adversarial system is followed in our legal procedure. The answer is mostly adversarial procedure is followed, and if you go to the courts in India, you will find that parties engage their own advocates, and advocates fight tooth and nail to establish their case, and the judge will finally give his or her own verdict on the judge and on the particular matter. But is this the case everywhere? And second thing which I told you, that in the common law family, in the adversarial system, the judges are appointed after having a degree of law. The judge must have undergone a particular study of law, obtaining a degree, LLB degree, and thereafter practicing in the courts for long years to become a judge of the higher court, and to become a judge of the Supreme Court, even a higher or the longer length of advocacy and advocacy skills were required. Now, is that the case only? Is there no difference? The answer is that mainly you all know that to practice in our country in the courts, we must have LLB degree in hand. So, what will you do? You will enroll yourself in a university or a college where LLB degree is offered, and then you will undergo the whole studies and examinations and then co-curricular activities. Now, it will take long 3 years or 5 years and then after 5 years what you will become? You will become a kind of skilled, technical, learned, trained advocate, and then you will go to the court and you will again try to imbibe in your advocacy skills, and then you become a judge. And then when you write the orders, when you give the judgments, your quality of judgment will be definitely better, or at least we can say definitely different from a judge in the civil law family of legal system. So, but what I was telling you, that is this the only speciality of our legal system? Is there no departure from this common law trend in our legal system? The answer is no, there is a departure, and in many cases, like I will tell you that after independence, when our country became independent in 1947, our country became independent. In the last almost 75, 76, 77, 8 years, what we have seen, you go and look at the scenario of the different institutions involved in the dispute resolution in our country, you will find that the dispute resolution in our country is also having not only courts, but also having tribunals, commissions. You might have heard about the National Green Tribunal. You might have heard about commission like the Commission for OBCs, Commission for SCs, STs, and you might have heard about National Commission for Consumers Disputes Redressal Commission. So, there are different commissions, there are different tribunals, Central Administrative Tribunals, Company Law Tribunal, Company Appellate Tribunals, National Company Appellate Tribunals, then commissions, Competition Commission of India. So, we will also try to learn about different courts and the jurisdiction of the courts in different lecture, but right now what I am telling you is that the whole system in our country is not only courts to decide the dispute or to resolve the dispute, but we have also the tribunals and the commissions. And what is the feature of those tribunals and commissions? You will find that the tribunals and commissions, they are not having the judges like the judges which are there in the courts. In the tribunals, in the commissions, who are the judges? The judges might be a person who was belonging to IAS. He was an Indian Administrative Service officer, and he served the government of India for 20-30 long years, and when he retired or she retired, then looking at the expertise of that person, what happened, that the tribunal, a particular tribunal hired or made that person a judge. So, this is what? This is the feature of the civil law family of legal system, where I told you that it is not mandatory in the civil law family of legal system that a person must have got the particular training in law, only then he or she can become judge. So, this is not there in the civil law family, and in our legal system also, when the moment the tribunals and the commissions, look at the Competition Commission of India, you will find that people who having served in the government or maybe that in a private sector, but the examples are very rare, but even there may be possibility that people who are in the private sector, they also may be called upon to become a judge, and they can be put in the panel of the tribunals. But here in our country, this system that having a panel of judges on the whole tribunals list, that is not there. So, even in our country, although we have the tribunals, which is a feature of civil law family of legal system, but in the tribunals also, in the commission also, what we find that there is a whole rigid system of appointing a member of Competition Commission, appointing a member of the tribunal, and then those people, they will also behave like a person of the judiciary. So, this is but again this is an influence from the civil law family of legal system, and because of the fact that the tribunals are being created, now you will find that the tribunal should be flexible. The courts in the common law family of legal system were rigid. They had to abide by the whole laws and procedures and the law on evidence, but the tribunal system or the commission system is not trying to always they will not be bound by the laws and the procedural laws and the evidence laws. So, what was the motto? Motto was that it will be flexible. These tribunals will be flexible and they will deliver justice in a shorter span of time, because they will not be bound by the rigid laws. But in our legal system, what we are finding, that because of the fact that I told you that the flexibility, the whole purpose was flexibility, but the behavior of the members of the tribunal and commission is also like they are much more influenced by the judges who are the chairperson of the tribunals. So, what happens is that that there is also a pendency, because I told you that the whole problem of pendency in the courts, that is because the judges have to follow every rule, every procedure, and they do not have any fault because they have to do it. But then ultimately what happens, there is a error, there is a pendency in the courts. To avoid that pendency, what happened, that this commission system and the tribunal system, those were created, that let us have less pendency, let us provide some flexibility to the judges of the tribunal, so that they will deliver the judgment very frequently and there will be no errors. But even if you look at the website of these different tribunals and commissions, you will find that they are also having errors, and they are also not taking up the cases which should have been, like they should have also decided in 6 months or 1 year. But I have heard and I have come to know that these commissions and tribunals, they are also taking a lot of time to decide, because of greater influence of the common law family of legal system. So, what I was telling you, that our legal system is based upon the adversarial system, and although in the tribunal, in the commission, there may be the possibility of following the inquisitorial procedure, but still the adversarial system, we are so much enchanted with the adversarial system that we forget for what purpose it has been made, or maybe that because of the atmosphere of delay in the whole country. So, that is also the thing. But what I was saying, that our legal system is having the feature from the common law. For example, justice, equity and good conscience. Now, this justice, equity and good conscience was the product from the common law. Although we had this feature initially when our legal system had started growing even before the advent of Christ, but our legal system was more focusing upon justice and good conscience. But as far as equity in the English sense, that was concerned, and all these three words were mixed during the British time, and when they had no codified laws, then how the judges they decided the disputes. They decided the disputes on the basis of justice, equity and good conscience. So, they thought that if there is a good conscience, if there is reasoning, there is a whole person who is having good descent and they are having good family, they may have good conscience and the sense of justice. And what is the meaning of equity? Equity meant that the rigid rules of law, that may be very harsh, and judges should be given some power that they will apply some principles by which they can remove the rigor or the harshness of those laws by following certain principles of equity. So, equity means that giving kind of level playing field if other party is very powerful or other party has, suppose for example, one of the rule of equity may be that if you are coming to the temple of justice, you should not be dirty yourself. So, these are some of the things that how justice, equity and good conscience, those were accepted by our own legal system when the Britishers were there. So, as far as the inquisitorial system is concerned, the inquisitorial system, I told you that that is also being followed in our country, and in the inquisitorial system what will happen? The judge will have the power to play an active role in the whole procedure. Now, is this feature present in our country? The answer is yes. We will see that section 165 of the Indian Evidence Act, if you look at this section, then you will find that 165 empowers the judge to ask any question to the litigants or the advocates who have come there, and this section says that if a judge wants to get at the truth, then judge can ask questions and judge can also go at the bottom of the matter by ordering fresh inquiry, by ordering fresh collection of evidence, and in this way the inquisitorial system is also linked, or maybe that it has influence in our own country. So, this is one example of, you see, that Indian Evidence Act is not only applicable on the other means the higher courts. Indian Evidence Act is applicable to all the courts, including the district courts, and most of the practice relating to the evidence, that is being followed in the district courts only. So, if a judge of the district court will have this power and they will use this power, then maybe that they can have good amount of powers, inquisitorial system of powers, and they can go at the bottom of the matter and they will bring the truth out of the whole dispute, and finally the justice may be delivered. So, inquisitorial system is also having influence, and when we talk of Indian Evidence Act, we have just talked about section 165. Now, we have the Indian Evidence Act, we have a new law on it, and new law, but that law, in that section 168 of the Bharatiya, what we say, Indian Evidence Act, new Indian Evidence Act, that section 168, that is the same as section 165 of the Indian Evidence Act, and Bharatiya Sakshya Adhiniyam. Now, we have the Bharatiya Sakshya Adhiniyam. So, that has the corresponding section 168, where the judges are given this power, but there is a little bit dilution of the powers of the judges in the new act. So, when you look at the new act, you will find that original 165 powers, that is lacking. So, section 165 is there. Apart from section 165 of Indian Evidence Act, you will find also section 11, which is not ditto the common law family or following the common law family. So, section 11 is about the admissibility of evidence, and normally the rule in the Indian Evidence Act is that relevant evidence will be admitted in the court of law. But section 11 was a departure from the British rule or the common law trend, and section 11 was saying that what you have to do, that even if a fact which is not otherwise relevant may become relevant in the court of law. So, it means that this was the departure, even if the fact is not relevant, but how can it be made relevant? Now, this was a practice of our own court, and therefore, this practice was accepted by the drafters of Indian Evidence Act. So, this is a departure from the common law trend, where they had no such rule. They have just the principle of res gesta, which says that only relevant facts will be considered admissible in the court of law. Coming on to other portions of our legal system, you will find that there is also personal laws. So, there you will find that the Hindu laws will be followed amongst the Hindus. When one Hindu will marry other Hindu, then what will happen, that the personal law Hindu Marriage Act, that will be applicable. And likewise amongst the people who follow Islam religion, they will follow the rule which are there in the Islamic or the Muslim law. So this is also important. We have also some Jewish community, we have some Christian community. So in our legal system we will find that these laws are also important. And if you go to Goa, if you go to Daman and Diu, if you go to Pondicherry, you will find that in these places it was not our own common law trend were continuing there. If you go there, you will find that they had been applying the civil laws like Napoleon code. The code Napoleon was applicable in Goa for a very long time, and even today code Napoleon is being followed in the civil laws. For example, laws relating to marriage, laws relating to business, laws relating to partnerships. So they follow this Napoleon Bonaparte. So in our country we have different streams of the legal system, and we have the influence of the common law mainly, and then we have also the little bit of direction towards civil law inclusion, and then we have the practices of different religions which are also acceptable, and we have also the tribal laws which are there in also some portions of our country, and the tribals, they do not follow the mainstream laws, and even our constitution has excluded them following the mainstream laws. Recently you might have heard that the Uniform Civil Code, which has been promulgated in the Uttaranchal, Uttarakhand, that has also excluded the tribals from their application of laws. So you see that there is one portion which is the areas where the tribal people they reside, the Vanvasis they reside, there the mainstream laws will not be applicable. Because they have their own system of laws, they follow their own custom based rules, they follow their practices, their own practices, and therefore that is respected. So even today what we see, that our constitution, which is the highest law of the land, that has accepted the tribal laws in our country. Whatever tribal rules and regulations are there, this will not be changed by the codification of the main laws, because you see that the codified laws will be applicable upon the whole country, whereas if you say that even the tribal will be affected by this, then this will not set a good example. The Britishers, when they were there, they had also not touched that portion where the tribal people, the native, the original inhabitants, they were living. So here comes the fact that our legal system is simply not now, at least after 78 years of the independence, we can't say that our legal system is only a stooge of the common law family of legal system. We are not. We are developing our system. We have also our domestic institutions. For example, we have our own, you see, Nyay Panchayats. So this Nyay Panchayat system is also present in some portions of the country, which is not there in many other systems like common law family or the civil law family. So this system is that the whole system, what we say, that village panchayats and then Nyay Panchayats, how some people they will gather together and they have the knowledge of the local laws or maybe dharma shastras, or they are acquainted with the Vedas and Smritis. So they can also resolve the dispute, applying their mind on the matter, then they can also do it. So our legal system is not just aping the West, but our legal system is also trying to conserve the things which were continuing from the past, and in the recent years, in the last 13-14 years, we may say that there has been a revived focus upon the old laws which were there, which were given by our own saints and sages and seers, and now this revival of interest in those laws, that has given a spurt to the study of the customary practices, the customary code of contemporary behavior, that how people behaved in those times, and how the change is there. So, gradually maybe that in the coming years we may see that, even because in the last 50 years what happened, that the courts and the advocates, the new advocates who were coming up, they were forgetting the Dharma Shastras and the Vedas and Smritis, and they just focused upon the legislation, the codified work, because they thought that legislation will be very easily applicable in the courts of law, and therefore they gradually were forgetting that what we had and how is it comparable, how is it different from the common law family of legal system, from the civil law family of legal system. So, when we come to our legal system, we also find now Lok Adalats. So, we will discuss about Lok Adalat in a special way or in an elaborate way in the next lecture, but just now what I will tell you, that our legal system is about also having Lok Adalats. So, if you have a matter which is a compoundable thing, and if that matter you want to resolve not in the court, but in the Lok Adalat, now that is also a possibility. So, this kind of system is not a system of the common law or the civil law family. So, this is our own system which we have developed. So, Lok Adalat, people's courts, those are also established, and we will see that how these Lok Adalats were established in our country. So, what we try to understand is that our legal system is following the different systems, common law, civil law family, the what we say, the practices of different religions, and lastly, what about the socialist family of legal system? Do we have any influence from the socialist family of legal system? The answer is yes, to a little bit extent. Why? Because if we look at the highest law of the land, we will find that our constitution in its preamble itself has inserted the word socialist. If we remember our preamble, we will find that we, the people of India, having solemnly resolved to constitute India into a sovereign, secular, and then socialist, democratic republic. So, it means that the amendment, although this socialist word was inserted by way of amendment in the 70s, but even today this has not been deleted, this has not been removed from the constitution. So, this is there. It means that the socialist laws had little bit of influence, and also if we look at the directive principles of state policy, which is there in chapter 4 of the constitution, we will find that the provisions of the directive principles, major provisions of the directive principles of state policy, those are also influenced by the socialist family of legal systems. For example, article 39 of the directive principle of state policy, where its clause B says that the material resources of the country should be redistributed to promote equality. So, this I told you in the last lecture that the socialist family of legal system that promotes equality, there should not be inequality amongst different citizens. So, the directive principles of state policy that had enshrined this provision that the states are directed to make those policies by which the material resources will not be concentrated in some hands or in few hands, rather it should be equally distributed. And therefore, what we see that our legal system has also influence from the socialist family of legal systems. And you see, when we talk of labor, the rights of the labor, the rights of the farmers, then there also you might remember that when the law was recently made for the farmers got agitated, they struggled a lot, and then the law had to be withdrawn. So, this is also example of a struggle and then causing a particular legislative wish to be withdrawn because there was a popular struggle. So, you see that so it means that our legal system is not just a system which is following the legislation or the state made laws, but sometimes the state makes laws, and because of the wishes or the struggle or the concerns of a section of the people, maybe that the law can be withdrawn also. So, this is our legal system. This is the beauty of our legal system. And you see that the people who belong to the labor class, we have different welfare legislations. And you see that Trade Union Act of 1926, which was made during the British time, that Trade Union Act has been also amended, and you see that now the trade unions, they are having, because now our legal system is following a liberal, or what we say privatized economy, and liberalized, and what we say globalized and privatized economy. So, in that scenario, you see that the influence of trade unions, that is decreasing day by day, and the government, although is saying that we will have a new labor code and this will be implemented soon, but many people, they say that the new labor code is diluting the powers of the trade union, because earlier in the last 50-60 years, the trade unions, when they were playing a very powerful role for the cause of the laborers in the factories mainly, in those times what happened, that trade unions became very powerful, but the people, the laborers, they had the same situation. So, we have seen that our legal system has kind of mixture. It is called a hybrid legal system. We follow socialist family of to some extent socialist family of legal system, and to little bit more extent to the civil law family of legal systems, and to the most extent the common law family of legal systems. So, I hope that you must have understood about our legal system. We have also followed some sui generis system and like that. So, this is the moot point. After this class, you must try to understand or discuss with your friends that how can we reduce the pendency in the courts and in the tribunals also. Tribunals were not considered as the places where there will be any pendency, but today the tribunals and the commissions have also the pendency. So, we should discuss this thing, develop your mind, try to analyze these things, that how the major legal systems of the world have tried to affect our legal system. So, this is how we must understand about our legal system. Thank you.
Many a times we all think, who am I? Why am I doing whatever I am doing? Why do I feel attracted towards others? Why do I feel very aggressive in certain instances? Why certain people or certain type of acts they repel me? Why is it that I always search for certain things which look very, very ambiguous? These are the things, these are the questions that all of us experience, all human beings. And you would realize that many a times certain domains of knowledge, especially within social sciences and all sciences at large, when you look at it from a philosophical point of view, they would try to give you the answers to these questions. Now, one of the branches of understanding which helps you understand things much better, which also helps you understand not only what is visibly present before you, what is glaringly apparent to you, rather which also tells you what is not visible at all, what goes within. Okay. And this is the subject knowledge, what is called as psychology. It is not only that it helps you understand the manifested behavior, the overt behavior, how you talk, how you speak, how you say it, how you interact, how you respond, not only that, but also what goes within, what makes you do this, what makes you think this way, what makes you act that way. Why is it that certain things you appreciate, certain things you feel attracted towards, and why is it that many a times in certain type of situations you feel you should completely go out of it, you should not get anyway involved into it, the repulsion. Why is it that certain acts, although you do not appreciate, still you get involved into it? Then you reinterpret your own behavior and you start giving birth to certain type of experiences, shame, guilt, pleasure, appreciation. You see world in a particular way, you analyze it in a particular way, you derive emotion out of it, feeling out of it, and the mix of what you perceived along with what you experience, it makes you act in a particular way, respond in a particular way. Your response is received by somebody else, and then the other person also responds in that situation. Now, there are situations where several people interact simultaneously, the situation remains constant and different people interact at the same time. You realize that your identity gets lost. You are not an individual, you act what is called as group behavior. You realize that you do not have an explanation for either favoring somebody or completely being unfavorable to the other person. You later on realize that it was a favorable or an unfavorable attitude towards that individual. You realize that you repeat certain form of behavior. Why? You do not know. People tell you that such type of repetitions are not normal. Human beings largely do not do that. And then you realize that okay, this is a particular pattern of a behavior for which I require the help of a specialist. The specialist tells me that this pattern of behavior is given a particular taxonomy, a particular nomenclature, which is either some aberration in the normal behavior, it is a neurotic form of a behavior, psychotic form of a behavior, it could be a psychosomatic response. And psychology, it covers all of this. So, if you want to understand yourself, if you want to understand others, this is the subject which helps you achieve that target. It is behavioral sciences that makes you understand human beings, human responses, human existence in complete totality.